Hello, everyone. We'd like to welcome you to the H1B Visa Alternatives for SaaS and Tech Companies, an Envoy Global webinar. For today's webinar, there will be two presenters. My name is Manu Sivanandam, and I'm the Chief Operating Officer at Envoy Global, and the COO. I oversee our service delivery and work both with our US inbound immigration services and also with our global immigration services as well. Joining me in today's webinar is Alison Kranz. Alison Kranz is a highly experienced immigration attorney and is Envoy Global's immigration solutions partner. And as such, she works with us and with our customers and has got deep experience working with companies of all sizes and across all industries, and immigration practice in her past career has covered a wide range of different immigration options. Before we go into today's webinar, just a little bit about Envoy Global, for those of you who are not as familiar with us. So Envoy Global started out almost 20 years ago, and we started out because we saw that the immigration process was becoming very frustrating, confusing, and wasn't as transparent, as efficient as we felt it could be. And so Envoy Global brought to the market an offering which combines expert legal representation with innovative technology to make it a much more efficient, transparent, and easy process, both for HR teams and for employees. And just a little bit about us. So as I mentioned earlier, we provide immigration services, both in the US and worldwide. We have 60 global partner offices and can manage immigration needs in over 190 countries. We have around 1,000 customers, and they span all industries, with a very high number of SaaS and tech customers across the country, and span all sizes, including startup and early-stage growth companies, all the way through to Fortune 50 companies. We're particularly focused as a company on customer experience, both for our HR teams and employees. And we're particularly proud of our NPS score, which is above 80, and we believe is a reflection of the service that we're able to provide to customers. So that's about us. In terms of the companies we represent, we work with companies across the spectrum. However, we do have a relatively high concentration of customers in the tech and SaaS space. Many of our customers are high growth companies recruiting STEM talent, and we very much understand the needs of SaaS and tech companies that pertain to them, recruiting this talent source and also often scaling at 50 or 100% a year, and we're able to scale and work with those customers. So that's enough about Envoy Global. So in terms of the agenda for today's webinar, we'll first provide a very brief overview of what we see on the global talent landscape. And in part, this builds on some research we've done where we surveyed over 400 HR professionals to get their views on what they see as best practices and what they see as trends in the immigration landscape. And we'll then spend the bulk of this webinar, which will be led by my co-worker Alison Kranz, going through H1B visa alternatives and best practices. And finally, we'll leave time at the end for any questions that you may have, which you can submit those questions using the GoToMeeting webinar app on the right-hand side of your screen. And just as a quick disclaimer to note, all the information we provide is purely for information purposes and is not meant to in any way act as legal advice. For any legal advice in a particular case, please contact us or contact your attorney. This is merely to provide an information context for you around different visa alternatives for H1Bs. So first of all, the global talent landscape. So I'm sure many of the numbers you see on this page will not be surprising to most of you. And so as I mentioned just now, we ran a survey across over 400 HR professionals, and the trends we saw were pretty consistent to what we've seen in prior years, that HR teams have seen a really significant skill shortage, 84% citing that they're seeing a skill shortage in applicants. We also found that or 40% of employers are struggling to fill positions. And this is actually the highest talent shortage we've seen since 2007. And finally, at the very bottom, you'll see, and again, I'm sure this won't come as a surprise to many of you, that we're seeing at the C-level from CEOs that government regulation is proving to be one of the major challenges they face in attracting and retaining talent. Within the SaaS industry itself, we have here some facts on the overall marketplace, and then a little bit of a segue into what today's main topic will be. First of all, we recognize the incredibly high growth of SaaS players, and we see that in our clients, and we see that, as I mentioned, in our clients who are scaling up their employee base often by 25, 50%, or 75%, and with that, of course, dealing with the immigration requirements both in the US and overseas. And that's something that we very much work with our clients on. So for today's session, I'm going to hand over now to Alison Krantz, who'll be walking through the main topic, which is H-1B alternatives.
All right, thank you. Well, thanks for having me here. It's great to have everybody on the line. We always get a lot of good questions when we're going through this today. So, as you're listening, as you have questions, can't emphasize enough, ask the questions because we want to provide you with the information that you need and that you seek. You'll see there's more information in the presentation than what we're actually going to be able to present you today. But we at least have some context for you here. We have some slides you can take back, but also we're always a resource to you. So if there's something that resonates that we don't go into great detail and you want to learn more about, reach out and feel free to contact us at Envoy Global. We can have a chat with me specifically about what my thoughts were on a particular issue that we discussed or something you want to get into more. So keep the good questions coming and we'll go from there. Now, one of the reasons that we're targeting SaaS companies in this particular presentation is because SaaS companies we found really utilize and rely on the H-1B visa. And I'm sure everybody on this call by now knows they are limited in number. And because they're limited in number, what are we going to do when they run out, right? Only 85,000 a year are available. It's just a major problem for your industry specifically. But there are other options and there's some alternatives to talk about. So let's move forward with that and we'll get into these alternatives and best practices. Now, starting off, I have some good news and some bad news for all of you today. You may or may not have heard just recently, the end of the month, July, USCIS announced that as of July 30th, it has returned all H-1B cap subject petitions that were not selected in the lottery. Okay, so employers, if you have submitted an H-1B cap subject petition between April 2nd and April 6th of this year, you should have received some type of communication or notice, and if you haven't, you will by August 13th. That is what USCIS is saying. The good news, the bad news in that is hopefully those who have been selected already understand that they're selected. Those who have not, the end is near, or perhaps they'll get some good news in the mail. It's a possibility, right? So we'll hope for the best and we'll wait for that. One of the exceptions, before we get into alternative visas, that I want to mention that people are probably already familiar with, but in case you're new to the immigration space, I'm going to mention, is that there are some H-1B visas that are exempt from the numerical limitations or exempt from the cap. Okay, there are certain type of visa applications for H-1B specifically or that are not subject to those 85,000 available H-1B visas per year. And that is for organizations, okay, and it can be a private organization, but they have to be related to or affiliated with an institution of accredited higher ed, so universities, college, community colleges that are accredited institutions, or government research organizations, okay? And that can be a private government research organization. It doesn't necessarily have to be like a .gov website, okay, or an actual government office, because a lot of the former government industry has been privatized. All right, so some of those national labs that used to be owned by the federal government are now owned by private organizations. So if your company happens to have a relationship or a contract and have some type of relationship related to or affiliated with higher ed, or government research organizations, reach out to your attorneys and have that conversation, because it may or may not have come up before. And if there's a possibility that someone you're interested in hiring is going to be involved in some of those programs in some way, you might have an alternative and be able to get an unlimited number of H-1B visas if that meets the requirements. So best of luck in that, but let's move on to the other visa types, other options that we have. One of the first ones I'm going to talk about is very similar to the H-1B visa. The requirements are nearly identical, except that it was created by a treaty with the country of Australia, and it is limited specifically to Australians. So if you have an individual who would have otherwise qualified for an H-1B visa, as far as you're aware, and your attorney is aware, and they happen to be an Australian citizen, the E3 is a great option for you. Now, these are also limited in number. Okay, there's only 10,500 available per year. However, to the best of my abilities and the best of my knowledge, I don't believe that that cap has ever been reached before. These are usually available year-round. Well, I shouldn't say usually. They're almost always available year-round, and I've never been aware of a circumstance where they weren't. So if you happen to have someone in that situation, that might be a good option for you. Similar to the E3, we have another visa type also created through treaties, and that's the H-1B1. This one is available to citizens of Chile as well as Singapore. There's also the numerical limitations where we have only 5,400 available to citizens of Singapore and 1,400 available to citizens of Chile. They are a little bit different where they only have a 12-month validity period, but there's no maximum. So a lot of people understand that the H-1B has a maximum period of 6 years in total, with some exceptions that have to do with green card processing. But this one can be renewed over and over and over. So there's another benefit here. Also, unlike the standard H-1B visa, we have some variations for certain professionals, not always necessarily dealing directly with the SaaS industry, but I mentioned them here at the bottom of the slide, just in case any of you have certain contracts with these types of industries. That's also something that would be very helpful for your attorney to be aware of, because there might be some wiggle room to have success if you do work with organizations that deal with disaster relief, or management consultants, agricultural managers, physical therapists. I know it's a SaaS webinar, but if you have those relationships, reach out and make sure you let your attorney know that, because you might have an option that you weren't aware of.
Alison, how long does it typically take to get one of these, to get a H-1B1 visa?
Not too long, okay? Not too long. So it's going to be similar to the H-1B process, where there's a longer way or a shorter way to do this. But we can go through the different consulate offices and kind of fast track some of these types of processes.
Great.
Another option, okay, is also F1 OPT STEM. Now you're thinking right now, and I can hear you, how is this actually an alternative to an H-1B visa? Usually students come to us from the university, right? And OPT stands for Optional Practical Training. After somebody graduates from a U.S. institution, they have a period of at least 1 year to work in the United States in a field related to what they were studying, okay? And people with STEM degrees have an additional 24-month extension on top of that. So we're talking about a period of 3 years. And what I hear you saying right now, and what we're seeing online is, right, I know, but we usually hire people right out of school. We use up that OPT time, and then we try to get people into the H-1B cap. And what I realize is, since the cap has been filling up, you're starting with year one applying for those H-1Bs. And that's a good strategy, right? Because it's a lottery and we don't know who's going to be selected. We also know it doesn't matter on the individual's credentials. It's a straight up lottery process. But what is important to know, and what has been scrutinized a little bit more recently with the F1 OPT program is STEM staying around? Okay, is the STEM extension going to continue? Because if you remember back in December of last year, DHS gave notice that it was considering ending this extra 24-month period of work, okay, and stopping the STEM degrees. Now, in December of last year, they gave notice that that type of proposal wasn't expected to be published until October 2018. Since that time, USCIS as well as DHS has been silent on that issue. We haven't heard anything one way or another, so we have no information to share there. However, since that time, during the spring, USCIS published a statement on its website, and that statement limited the ability of F1 students in the STEM OPT extension program to work at third-party locations. And that statement is outside of the law and outside the regulations that control the STEM OPT extension. Now, the reason why I bring that up is because when that statement, completely appeared on the website, it was really attacked by the legal community and immediately challenged. And USCIS was asked to respond in some conference settings, not officially on paper, and where the authority for this was coming from. Since that time, it has been reported as of June 2018 that third-party STEM OPT placements have been approved. There hasn't been a problem getting those through, but there's a lesson learned here. And what the lesson learned is that, what's really important to look at is that we need to submit detailed evidence of employer-employee relationship when we're doing that STEM program, okay? USCIS, by making that statement, told immigration attorneys around the country the employer-employee relationship is very, very important to the success of being able to file for OPT STEM, right? So when you're going and you're working with that designated school official on the training program and what this training program looks like, if you are placing somebody at a client site or a customer site outside your normal workplace, you want to make sure that you are really emphasizing how you're going to be watching that person, how you're going to be supervising, how they're going to be involved in an actual training plan, not just become kind of an outside employee of this third party. Okay, so you'll want to continue that so you have success in filing those OPT STEM extensions while you're trying to get on that H-1B visa. The J visa. The J visa is for non-immigrant individuals who want to come to the United States for a temporary period of time. There's a large variety of different types of J visas, but in particular, what would probably most apply to the SaaS space, the SaaS field, would be people who are in work and study-based internships or exchange visitor programs. The intent of these programs is to give someone from another country real-life experience working in the United States and then go back to their home countries and take what they've learned in the United States and implement that or share their experiences here. These are limited to an 18-month maximum period of stay. There's some exceptions to this, but that's a pretty steady hold rule. This solution is not right for everyone. There's some significant downsides to the J visa. The first one is that only the organization that sponsors a J has to be actually a J visa sponsor. Okay, if your organization, a private business, and most private businesses are not J sponsors, that means you can't sponsor them directly. That doesn't mean you can't employ them. That means first we have to identify an organization that has the ability to sponsor these special J visa students and interns, and then have the placement of employment be at your workplace. There's a lot of organizations that do this, and the reason why we need a special J visa sponsor is because during the period of internship or training, that individual actually has to be supervised, they have to be checked on, it has to be some type of educational program with a training component, because this is supposed to be that type of international exchange program. Also, because the purpose of this J visa program is to take these skills and to provide them to other areas of the world and country. Some programs and some individuals from certain countries have a requirement to spend 2 years after they've completed their J visa program in their home country. That's a pretty strict rule. There aren't too many exceptions to that. And so before you go forward, we're going to assume that you want to bring in talent, you want to keep great talent, and you want to keep them employed in your country, in the United States, and not have to go home to their home country. So, if you're not willing to lose someone after a certain period of time, you want to have that conversation whether that 2-year home residency requirement is going to actually apply to them or not.
And how do you know, Alison, if someone is subject to that residency requirement? What are some examples?
Sure. Well, the easiest way to do that is to actually contact your attorney and ask them, here's my hypothetical job description. Here are the credentials that this person has. This is the country that they're from. This is their citizenship. Would they be subject to this two-year home residency requirement? You can also do a little bit of research on your own. I recommend going to your attorney first, but ultimately there is a long list of what they call the J Visa skills list or the exchange visitor skills list. It was actually published back in 2009. That's the most recent copy. It's time for an update if you ask me. And what the attorney is going to do is they're going to go to the Department of Homeland Security's website, and from there, they're also going to, you can also find on the Department of State website too, that's available there too, if you're more familiar with that format because of consular processing. And they're going to look at this master skills list, that's actually named the list, to see if the field that they're working in is one of these needed skills from a different area, to be implemented in a different area of the world. From there, they actually next go to a country conditions list. From there, they look at the person's country. Is this two-year home residency requirement required? If so, under what categories? And then they take that category and match it to the master skills list. But hey, save yourself some time. Just give them a call. Let them do the work and give you the answer. They're happy to do that. Another option is the L visa. And the L visa is an intercompany transfer visa. It is available to individuals who work for multinational companies. And this is a situation where we have somebody who's working abroad in another company that's a parent or a subsidiary or has some type of legal relationship to the U.S. Organization that wants to sponsor this individual. And we're taking that employee and we're transferring that employee to the U.S. company. Okay. In order to do this, that individual is going to have to be working for that related organization for at least 12 continuous months within the last 3-year period. And that 3-year period is taken from the point the application is filed, and they go look backwards 3 years from there. That's usually not too much of a problem for multinational SaaS companies as the business keeps growing and industry keeps growing. That doesn't seem to be too much of a challenge. But within the L visa category, we have 2 subcategories, and we have L1A visas for executives and managers, and we have L1B visas for employees with specialized knowledge of the company. I'm going to dig into those in just a bit and a little bit more deeper dive into that situation. But I want to mention that what we're seeing more and more is SaaS companies leveraging their global footprint. Okay, if you're a multinational company and the H-1B visa didn't work out, and you have the ability to potentially take that person who would love to be working for you in the United States and place them abroad at a different company that you're related to, we're seeing a lot of companies go and put that person in that office in London or in that office in Hong Kong or Sydney and have that person work abroad for a year. Okay. Once you have that 12-month requirement, bring them back on an L visa. Now, the position that they're working in, of course, is going to have to meet the requirements of this L1A or this L1B visa, and we'll talk about that in a moment. But that can be a real solution for you because as that person's working abroad for a year, you can continue to apply for the H-1B visa, even if that person's not in the country, to try to bring them back that way. Also, the millennials, they love traveling. That's what we're seeing more and more. They're willing to locate. When we've surveyed employers, we came back with the employer-employee survey that 92% of millennials are willing to relocate. And so if a 1-year assignment doesn't sound too bad to me, abroad in a different country, it sounds like a benefit in some ways. So that might be something you want to leverage. I recommend before you go and decide that this is a strategy that's going to work for you, check with an immigration attorney to make sure that the assignment abroad meets the requirements of the L1A or L1B. You wouldn't want to be in a situation where you make that assumption and then a year later you go to start this visa process and you're told, oh, sorry, it's not going to work out for you. So check that out before you make that plan.
Right. And 2 common questions we get on these, Alison, are one is, are there any caps on the number of L visas that are issued? And the second is, can I apply any time of the year?
There are no caps. The caps are available. And yes, you can apply any time of the year. These are available year-round. There are some numerical limitations of how long somebody can be in the United States on these certain types of visas, but they have the L1A and the L1B. They have two different requirements. So let's actually get to the next slide and talk about the L1A. The L1A is limited to only 7 years. Okay, and so if that individual who was asking about caps and limits, if you're talking about the H-1B visa, we know the H-1B cap is only available for 85,000 individuals, and it is limited to 6 years. Okay, comparing that to the L1A, the visas themselves are not limited in number, but the L1A is limited to a 7-year period. The H-1B visa, you can go beyond that 6-year limit if you're at a certain point of the green card process. That is not the same for the L1 visa. Okay, with the L1 visa, it's not going to matter whether you're in that green card process or not. That is a hard stop at that 7-year period if the person is continuously working in the United States. Something else to keep in mind with that, when we're counting the 7-year period, and this is even true for the H-1B visa, only days physically inside the country are counted towards that 7 years. So sometimes it's possible to stretch that 7-year employment to longer once we subtract the time that somebody spent outside the country. With the L1A, we said that's available to executives and managers. Executives are pretty easy to define within an organization. Managers are a little bit harder, okay? And so what you want to think of this as is higher level managers. So we're talking about people who are supervising or directing the work of others. They have direct reports. They're managing an important aspect of the organization or a department or a subdivision. We're not talking about the lowest level line managers that maybe have no reports, only one report. I wouldn't rule those people out completely, talk to an attorney about it, but generally you can consider that as higher level managers. We also have the L1B visa, and the L1B visa is considered a specialized knowledge visa. Now don't confuse that with specialty occupation of the H-1B. It's something completely different. Okay, specialized knowledge is considered knowledge within a particular industry that is, a particular company that is not common. It's noteworthy, it's unusual, and it's not necessarily academic. Now, obviously, I'm sure that a lot of the employees at SaaS companies are highly educated and have lots of degrees, but this can even work out for someone who doesn't have a degree or someone who has an associate's degree who might not qualify for an H-1B visa. We can have somebody who has no degree but has worked for your company for a number of years and has a very specialized knowledge of your particular process, the way you do things, something that's proprietary to your company. Someone like that might also qualify for the L1B visa. These are available for a total of 5 years at a time. And again, there's a hard stop on that 5-year period. Let's go on to the next. The next one is the TN visa. TN was created through NAFTA. It is for individuals from Mexico or Canada. There is no limit on how many of these are issued per year. There's also no max out time. So someone can live in the United States on a TN for literally the rest of their life at the current time. There has been some questions about the future of TNs. Recently, the Trump administration, after the most recent G7 summit, had some words and some different statements to make about the future of the TN. We haven't seen anything happen or change with that since those comments were made. The suggestion was maybe we should be negotiating with Canada and Mexico individually rather than just through NAFTA. But at this point, nothing has come out, nothing has changed, and it might have just been words and not action. So we'll have to watch and we'll have to see how things go from there. What occupations are available to be on a TN visa? Again, we're using the word specialty occupations, but it's used differently than the H-1B visa. These are essentially professionals whose professions are listed on the TN jobs list. If you Google TN jobs list, I'm pretty sure the first couple links are probably just going to link directly to that list of jobs. There's everything from forest rangers to doctors to engineers to designers, a lot of different professions on there, and essentially that list was created by the 3 countries agreeing. So check that out and see what might be applicable to your organization. We also have two others that I'm just going to mention very shortly because I don't think it's going to impact your industry too significantly, but it's worth noting. We have the O1 visa, and this might be available for some companies who have individuals with very, very high level achievements. Okay, the O1 visa is for extraordinary ability. We're not talking about extraordinary ability where you've worked with the person in the cube next door and you think they're extraordinary, that's awesome, they're great, they're always on top of their assignments. No, we're talking about people who are literally some of the best in their field. So if you have someone who is at the very top of your industry, in the very top of your field, and that can be documented and proved through published materials in scholarly journals, professional trade organizations, if this person has had a lot of materials published about them, if they have a lot of citations on authored scholarly articles, if they have a very high salary, if they've had a critical or essential capacity in organizations with a distinguished reputation, if they have memberships in professional associations that are not just open to the general public but require some type of qualification to join. You might have someone with, according to USCIS, extraordinary ability, and they might qualify for this O visa. So it's worth looking into. It's worth having a conversation. E2 visas are for treaty investors and those individuals that are employed by them who also share the same nationality as them. The E2 program was created by treaty. It's not available to all countries. Essentially, if you Google E2 treaty investors list, there's going to be a big long list of all the different countries that we've actually gone and had agreements with to qualify with that. And there's no numerical limitations on this one either. Somebody can be in the U.S. for the rest of their life on this. And what your kind of key that you're looking for with the E2 is you're looking for an individual who is able to make a sizable investment from abroad and move their money to the United States to start a business and to go ahead and actually employ U.S. workers, or you're looking for someone who has already done that. They don't have to own the full company. They can just even own 50% would be possible. Also, these employees that they're bringing over that have the same nationality as them, they're considered essential employees, and they have key skills that will allow them to perform, the same duties that they did in the home country in the United States to the benefit of the company. Like I said, I don't think it's going to apply too much in your industry in particular, but perhaps you already have that set up. Perhaps the owner of your company has already done that, and you might be able to get certain foreign nationals from the country that person is from originally to the United States that way. So worth mentioning there. A couple of other things is, how about getting work authorization through a spouse? Okay, certain dependents are able to get work authorization because of their spouse's primary visa category. Okay, so the spouse of E1 treaty traders, which we didn't mention on this webinar because it's not quite relevant to what we're doing here today, but if their spouse is an E1 treaty trader, they're able to get independent work authorization of that and work at any company, as well as a spouse of E2, spouses of E3s, spouses of L1s, that's L1A, as well as L1B. The spouses of an H1B employee are able to get independent work authorization if a specific phase of the green card process has been completed. I know that can be a hard conversation to have sometimes with a job applicant, but usually those individuals are aware of that requirement and will volunteer that they are able to do that if they're applying for your job. We also have spouses or children of some programs are able to get independent work authorization. And so spouses of J1 exchange visitors are sometimes able to do that. And although we just talked about the J's and we talked about how they're limited in time for an 18-month period, those are two particular categories of the J visa that I thought were most applicable to the SaaS industries. There are some J1 programs that are much longer. For example, for medical graduates doing residency programs in the United States, that's a much longer program. Their spouse would be able to work while they're in the United States. So you might want to consider that. Also, we have certain circumstances that are very unique that would be evaluated on a case-by-case basis. Spouses or unmarried children of people who their primary visa beneficiary, okay, so the spouse would be in an E3, H1B, H1B1, O1, or L1 status. Their spouses and their children may get independent work authorization through other circumstances than what was mentioned here. If there's a very compelling situation, that's a very vague term. It's a very vague regulation. If something unexpected, strange, unusual, or overall compelling has occurred, there might be a way to get that person the ability to work in the United States. So here we are, about at the end of our time, and I think we have a couple of questions coming in. Yep. Just a few more.
That's great. Thank you, Alison,
okay, great.
for going through all of that. And just to underscore, as you mentioned earlier, if you are considering any of these options, please do reach out to your immigration attorney. So there are a lot of questions come in. I think we've got time to squeeze in a couple. So one, which has come up in a couple of different forms, so I'll paraphrase here a little bit, is for employees who are likely to pursue a green card path, are there any particular visa options you would recommend?
Yeah, I think one of the paths that should be considered that really hasn't been is that if you have an individual who is from pretty much just the way that the green card routes are taking right now due to backlog priority dates, essentially, long story short, the U.S. has a interest in keeping the company diverse and the country like a melting pot. I'm sure you heard that term before. Certain people from certain countries have a longer wait than others before they can get a green card. If you have an individual from any country pretty much other than China or India, considering starting their green card sooner rather than later. A lot of times, for some reason, people think that if I have a student on OPT, I have to wait to get them to another visa category before I start their green card. You don't. You can start their green card right away. You can start their green card even while they're still a student, potentially, and an intern at your company. It's something to think about. If you happen to have an individual who is from India or China, chances are they might need an H-1B visa eventually in order to not have a stoppage in work, to not have the break of not being able to stay beyond that 6-year period, unless they're in an H-1B status. What that means is you'll want to start that green card for people sooner rather than later. It also means if you're going to take advantage of one of the strategies I mentioned today, like, for example, sending someone abroad for a year to work at a subsidiary or a parent company for a year and bringing them back on an L visa, two different things to consider. If this person is not from India or China, why not start that green card right away? They don't have to be in the country to start that green card process. It can be started without them. And that might have the potential of saving you money in the long term because there might be one less extension that has to be filed for that visa. If we're talking about individuals that have a longer priority date wait, have a longer line, then if they're coming back to the United States in an L or another visa status, that means applying in every H-1B lottery until hopefully it's won, because otherwise we're going to have that problem again.
Great, thank you, Alison. And then one final question, which may be a long one, so I'll defer to you.
Sure.
Defer to you on this one to give the brief version. Are there any recent government policy changes that have impacted these H-1B visa alternatives?
There's a couple. There's been a couple recent announcements, and how they're going to play out, we're not exactly sure. We're waiting for more information. Recently, USCIS announced 2 different policy changes, one having to do particularly with the issuances of RFEs and NOIDs, that's request for evidences or notice intent to deny. These are communications issued by USCIS to applicants, letting them know that USCIS is not so sure that this individual qualifies for the particular visa category an application has been filed in. Previously, as of 2013, a memo came out and essentially gave guidance to officers suggesting that before a case is denied, if an officer thinks that an individual doesn't qualify for a particular category, that officer should issue that RFE or that NOID to give the applicant a chance to correct anything in the record, to clarify it, to provide more evidence, if that's possible, before actually denying the case. The new memo that came out said that that's not necessary, that officers do have the discretion to deny cases outright, and an RFE or NOID is not necessary to be filed before the denial occurs. So there's a slight policy change there. While it can definitely impact the industry and definitely impact people who are filing with attorneys, generally most attorneys tend to be more conservative with the applications that they're filing. Most attorneys understand that if they have a client who is paying them money for an application, they want that application to be approved, and preferably without an RFE or a NOID. So I don't expect to see a humongous change with those who are represented by attorneys, because the attorneys are going to do the best that they can to provide all that evidence up front. But there will, of course, be some officers who disagree or want something more and issue those denials right away. So I think there will be some impact, although hopefully it will be minor. There's also another memo that was recently issued about something called NTAs, or notices to appear. Those are the that's a charging document that places people into deportation. Previously, generally speaking, it was USCIS's policy to request a different department under the Department of Homeland Security to do an investigation and decide whether a certain immigrant should be placed into deportation proceedings or not. That memo is now broadening officers' authority to issue those NTAs, and has guided USCIS officers to actually give them specific examples of, here are more reasons that these NTAs should be issued directly by USCIS. Now, that involves other agencies within the government, and those other agencies haven't actually responded to what the plan is and how they're going to work around that policy change by USCIS. And so we're waiting to hear more about that, what that looks like, how it's going to impact employers like you, if at all. And when we have that information, I'm pretty sure we're going to be ramping up and having another webinar about it, because there's certainly a lot to talk about there.
Great, thank you, Alison. So that takes us to time. I'd like to thank everyone for joining this webinar on H-1B visa alternatives for SaaS and tech companies. As Alison mentioned, we will be uploading the materials used in today's presentation to the Envoy Global website, as well as a recording of this webinar. And if ever you would like further information, please do reach out to us at envoyglobal.com. Thanks again for joining today's webinar.